I'm Francis Wallace and I'm the head of our Dispute Resolution Department at Rix & Kay, and I'm going to say a few words about the procedures we have in the civil courts in England and Wales. We look after a variety of disputes involving the courts, as well as resolving the disputes by other methods, including arbitration, adjudication, which is something the construction industry has, mediation, and by negotiation between the parties. Sometimes clients are quite daunted by the apparent complication of the civil court system. So I'll say a bit about the main procedures which they may come across and some of the key documents which are used in the procedures. We have two main civil courts, which are the County Court and the High Court. There's quite a lot of overlap between the two, but generally the County Court is used for the smaller cases and the High Court for the larger ones. Having said that, money claims worth well over £100,000 are regularly dealt with by the County Court. In either court, the proceedings are started by issuing a claim form and particulars of claim, and those two documents set out what the claim is about. If it's a money claim, then they will say how the sum involved is calculated. A response pack is usually sent to the receiving party, the defendant, to enable him to respond to the claim form. The time limits for the response vary to some degree, but most of the claim forms require an acknowledgement of service to be sent back within 14 days to the court. If the defendant says on the acknowledgement that he intends to defend all of the claim, then he has up to a further 14 days to send in his defence, provided he gets the acknowledgement back within the time limit. If the defendant misses either of those time limits, then the claimant can usually apply to the court for judgment in default of defence. If the claim is for a fixed amount of money, then the judgment will be entered requiring the defendant to pay that sum. If the claim is for damages, the judgment will be entered in favour of the claimant, with the damages amount to be assessed by the court at a later date. If the defendant considers he has a claim of his own against the claimant, he may want to use that as a set-off against the sums the claimant is seeking from him, and if so, he should say that in his defence. The defendant may also want to bring a separate counterclaim at the same time as his defence. That's a separate legal action in its own right, and if there is a counterclaim, then the claimant should lodge a defence to that counterclaim, if he has one, within 14 days of receiving it. If judgment for a monetary sum is entered against the defendant, then the claimant may enforce the judgment in various ways. Very often that involves using the court enforcement officer, who used to be called the sheriff or bailiff, to visit the defendant's house and to seize and take away his goods for sale at public auction. Another enforcement method is a charging order, which is a mortgage imposed by the court on a property owned by the defendant. A third common way of enforcing a judgment is to apply to the court for an attachment of earnings order against the defendant's employer, and that requires the employer to deduct a sum from the defendant's salary every month and to pay that to the court, which then hands it on to the claimant. If the claim is defended, then the court considers how the case should be managed, and that's normally done by fixing a case management conference, which is a short appointment in front of a district judge. The first direction that the court gives is usually to fix the procedural track to which the case should be allocated. There are 3 procedural tracks, and they're called the small claims track, the fast track, and the multi-track. The fast track is for cases that can be heard in up to a day. The small claim track is for disputes of up to £5,000. The multi-track is for cases which will take longer than a day to hear, or where there's some other complication about them. The court will require each party to make a list of all its documentary evidence which is relevant to the case, and that's irrespective of whether it will benefit the claimant or the defendant to have that particular document put before the court. You're not allowed to be selective. You must disclose all the documents in your possession, whether they're for you or against you. And this is called the process of disclosure. The party who has the documents must provide copies on request to the other party. Documents include electronic documents such as emails and text messages. Parties are under an obligation to preserve evidence until the case is concluded, and they must not destroy or conceal any evidence which may be material, including deleting emails and that kind of thing. The parties also have to provide written statements for any witnesses who are going to give evidence at the final hearing. That includes the parties themselves normally. And those statements have to be exchanged between the parties by a certain date which the court will fix. Witness statements normally have to include a signed statement of truth, confirming that the maker of the statement believes the facts stated in it to be true. If expert evidence is necessary, for example from a surveyor or a technical expert, then the court has to give permission for that. The evidence normally takes the form of expert reports, generally from one witness for each party, one expert. Sometimes the court directs that the parties should use a single joint expert who advises the court on behalf of both parties. That can save costs. It can also be dangerous because the expert, if he's a single joint expert, is likely to be very influential in determining the outcome of the case if expert evidence is quite a big part of it. Experts are governed by strict rules, and they have to be non-partisan and advise the court on what is correct, and those duties override their duties to the party paying their fees. When the parties have complied with the various procedural steps, then a trial or a final hearing of the case will take place before a judge. It's up to the claimant as the party bringing the claim, or the defendant if he's bringing the counterclaim, which is a separate action as we looked at earlier, to prove his case on the balance of probabilities. Normally he does that by calling witnesses to give evidence and by producing copies of relevant documents to the court. The parties don't have to be represented by lawyers. They can represent themselves, and they commonly do in small claims where the value is £5,000 or less. It can be quite dangerous because the parties may not be familiar with the law. It's less dangerous in small claims because usually no costs are awarded against the losing party. But in the larger claims, costs generally are awarded, and those can be a great deal of money, often, or in many cases, more even than the amount in dispute. It's sensible for parties to a dispute to obtain legal advice at an early stage, even if they then choose not to instruct lawyers to represent them all the way through. They should try and settle their disputes by negotiation if they can. The courts regard issue of proceedings before the court very much as a last resort. The court is always willing to put a temporary hold or stay on the case to enable the parties to negotiate a settlement, or better still to mediate. Mediation is a process which involves the parties attending an appointment before a trained mediator. That is typically for a day in the larger cases, but it can be for as little as an hour or half an hour, and it can be done on the phone. But normally, traditionally, it would be a day or up to a day, depending on how long it takes. The mediator isn't a judge and doesn't make any rulings on the rights and wrongs of the dispute. The mediator is really there to encourage the parties to reach their own agreement, and that agreement may not be something either party sees as ideal, but it's something which they can live with. That can be a really successful way to settle even complex commercial disputes, and it has the added advantage that it may enable the parties to go on having a business relationship after they've mediated an outcome. Very often that's not the case if you go through the court process, through a trial, and end up with a judgment by one party against the other. It's very important in any kind of court process to read and obey orders issued by the court, particularly orders requiring steps to be taken by particular dates. If you don't do that, then normally you are sanctioned in costs. You have to pay the other side's costs for whatever it is you haven't done, where it's put them to expense or inconvenience. You may even get your case dismissed if you're in breach of a serious order of the court. There's a lot of useful information on the Ministry of Justice website about how to issue and defend claims. That's just a starter really. If you would like some more specific advice about a case, then our team are always on hand to assist you. We undertake a wide range of work, and to mention a few things, we deal with commercial disputes, disputes about money, landlord and tenant arguments, construction disputes, disputes over intellectual property, including trademarks, and also bankruptcy and insolvency. We have specialists in all of those areas who have years of experience in the fields concerned. I hope that's been an interesting introduction and has given you a few guidelines into some of the issues you may meet in the court process in England.